Sir, despite the size of the real estate market in Mauritius, real estate agents are up to now largely unregulated. The only requirement is that anybody wishing to operate a real estate business need to get a general business license from the local government authority and pay the prescribed license fees. As many speakers intervening before me has pointed out, there was a risk posed by real estate agents who were not honest, and there was a need to protect consumers, against real estate agents who overcharge them, need to protect the public against real estate agent who does not complete the sales after having taken their money. And here, I take strong exception to honorable members on the other side who keeps referring to honest people as courtiers marrons, as if it is those poor people trying to earn a living decently who are to be blamed. Whereas in fact, there are land promoters, rich property developers who have been selling property off plan, vente en état futur d'achèvement, who took money from the public and then went into liquidation, and the public lost a lot of money in the dealing. So yes, there is a case for regulating the sector, and we, on this side of the house, we don't hold any brief for any courtier. But when there are shortcomings in a bill, it is our duty to highlight any shortcoming in the bill. There is a need to put some order in the House, and as far back as 2016, the Law Reform Commission, in a paper entitled Legislative Framework for the Regulation of Activities of the Real Estate Agent, already recommended two options. One was to come up with a substantial piece of legislation. The second one was to amend the Code de Commerce. But in either case, what the Law Reform Commission recommended was the setting up of a real estate agent authority, or a condition de la transaction et de la gestion immobilière with disciplinary powers to sanction any real estate agent, any land promoter, any property developer in case of misconduct. So the bill behind the House today, Mr. Speaker, sir, incorporate many of the features of the model legislation that was already proposed by the Law Reform Commission 4 years ago. But as rightly pointed out by the Honourable Deputy Prime Minister and the Minister of Financial Services after him, the aim of the bill is not just to regulate the activities of the real estate agent, it is also aimed to combat money laundering and financing of terrorism in the real estate sector. Real estate is attracting for money laundering, not only because it's a very easy way to convert ill-gotten gains into legitimate income, but it also provides a safe investment in an appreciating asset. The Commission of Inquiry on Drug Trafficking, in its report published in July 2018, identified the purchase of immovable property as one of the preferred methods used by drug traffickers to launder money. The Commission found that immovable properties were purchased by persons using prête-nom. The purchase price was paid by one person, but the property was put in the name of another person. Seems very familiar these days. And when the property was sold subsequently and the check deposited in the bank would ask no question because it was satisfied that the money represents proceeds of sales of property. Now, Mr. Speaker, sir, we all know how easy it is to launder money through real estate. Let's suppose there is a drug trafficker who wants to launder 1 million rupees. He buys a property for 5 million rupees. However, before the notary public, in the title deed, he puts only 4 million as the purchase price. The difference, the 1 million rupees, is paid under the table, under la table, in Mauritius or outside Mauritius, for that matter. And then the criminal subsequently sells the properties as a profit and by doing so, he has already been able to launder 1 million rupees. The fact that until a few weeks ago, it was possible for real property to be purchased with cash payment being effected or la vue du notaire further assists criminals to launder proceeds of crime through the acquisition and disposal of real estate. Now, if we are dealing with criminals who are a bit more sophisticated, the criminal will use a number of companies and intermediaries in the layering stages to hide the tainted source of funds as much as possible. For example, the criminal may buy property using a loan from a company and then sell that property to another company at an overvalue, making a huge gain. It all seems perfectly legitimate, it all seems very kosher, but in fact, the ultimate beneficial owner of these companies are all related to him through prête-nom, through nominees, through trust structures. Now, I don't want to give too many examples of how money is being laundered through real estate, because I don't want to give ideas to anyone, but there's extensive literature on the subject. So it's no surprise that according to the Commission of Inquiry on Drug Trafficking, the Financial Intelligence Unit, FIU, had identified 24 cases of drug traffickers laundering their ill-gotten money through real estate between 2011 and 2015. This is in the report. So 24 cases of drug trafficking laundering their money through real estate. And yet, the Commission observed that no notary public had ever reported any case of suspicious transaction. Not a single public notary. Honorable Kabir Ameno has his name on the bill as he's going to intervene later on. I'm sure that he will justify why public notaries see no evil and never report any cases of suspicious transaction in real estate sector when the FIU themselves has conceded that there has been at least 24 cases where drug traffickers has been laundering money, proceeds of crime, through real estate transaction. Mr. Speaker, sir, the risk of money laundering through real estate in Mauritius is even greater today when we take into consideration the purchase of real estate property by foreigners, be it under the Integrated Resort Scheme, the Real Estate Scheme, Property Development Scheme, the Smart City Project, and all these other schemes available for foreigners to invest in real estate in Mauritius. Again, in its report, the Commission of Inquiry on Drug Trafficking stated, and I quote, "The Commission has been informed by FIU of cases of money laundering in the offshore, as well as traffickers from South Africa through their lawyers purchasing integrated resort scheme property." Again, FIU very much aware of foreigners from South Africa investing in real estate projects in Mauritius as a means for money laundering. And yet, up to now, I have not heard any action being taken against anyone in the real estate business, be they a member of the public notary or a member of the real estate agent sector. And we should not forget, Mr. Speaker, sir, the famous Mr. Alvaro Sobrino, who wanted to purchase several villas in Royal Park for several hundred millions of rupees. Honourable members will remember that this led to the resignation of Mr. René Leclésio as member of the then Board of Investment on 21st September 2017 because he refused to condone such practice. I asked a PQ on this matter on the 7th November 2017. A senior counsel from the private sector, a member of the bar, had advised the Board of Investment, as it was then known, against allowing Vango, a company owned by Mr. Sobrino, from being allowed to purchase those properties because of the reputational risk to Mauritius. And it is thanks to the intervention of Mr. Gérard Samper as chairman then chairman of the Board of Investment, that the Board of Investment imposed as condition to the approval of the investment by Mr. Sobrino, that a report from the forensic expert firm, Kroll, be commissioned to look into the source of funds of Mr. Sobrino, who was going to invest several hundreds of millions of rupees in real estate property in Royal Park. The sale did not go through. As I understand, Mr. Sobrino could not satisfy the Board of Investment of the source of his funds. But no suspicious transaction report was filed by the land promoter or property developer. No suspicious report transaction was reported by any notary public, by anyone from the real estate sector. Yet, Mr. Speaker, sir, as far back as 2009, I repeat it, 2009, 30th July 2009, more than 11 years ago, the Finance Miscellaneous Provision Act amended the Financial Intelligence and Anti-Money Laundering Act, FIAMLA, to include, in his definition of member of the relevant profession or occupation, any land promoter and property developer, agent in land, building, or estate agent under the Local Government Act 2003. I repeat, as far back as 2009, real estate agents were already subject to the supervision of the Financial Intelligence Unit. And when in 2012, the Economic and Financial Measures Miscellaneous Act further amended FIAMLA, the definition of member of relevant profession again included agent in land and or building or estate agency under the Local Government Act 2011 as member of the relevant profession and occupation. So still under 2012, these real estate agents were still being under the supervision of the FIU. So as far back as 2009, Mr. Speaker, sir, real estate agents were required by Section 14 of FIAMLA to report to the FIU any transaction which they had reason to believe may be a suspicious transaction. Today, we see in the bill before the House, Mr. Speaker, sir, at Section 23, Subsection 1, that real estate agent has to report a suspicious transaction not later than 5 working days after the suspicion arose. A lot of honorable members who intervened before me thought that this is a breakthrough in the law. In fact, this is identical word to word from Section 14, Subsection 1 of FIAMLA, to which real estate agents are already subject to since 2009. Again, if we look at Section 23, Subsection 2 of the bill, which make it an offense for real estate agent not to report a suspicious transaction and make them subject to a fine of 1 million rupees and an imprisonment of a term not exceeding 5 years. Again, this Section 23, Subsection 2 is taken verbatim, word to word, from Section 14, Subsection 3 of FIAMLA. So this bill is not doing anything new as far as regulating real estate agents in this matter. In fact, the FIU even has a whole page on their website dedicated to real estate agents. So, Mr. Speaker, sir, the problem really was not with the legislative framework. The problem was that real estate agents were not reporting any suspicious transaction to the FIU, and the FIU was not properly supervising the activities of real estate agents. And this was a problem. Failure of enforcement agencies to do what they are paid to do, a sense of laissez-aller. And when the Eastern and Southern African Anti-Money Laundering Group, ESAMLAG, published its mutual evaluation report in July 2018, they were quick to pick up on these shortcomings. Real estate agents, Mr. Speaker, sir, are technically referred to as designated non-financial businesses and profession, or DNF-BPs for short. And ESAMLAG found Mauritius to be non-compliant with regard to recommendation of the Financial Action Task Force with regards to the real estate sector, namely Recommendation 22, Customer Due Diligence, Recommendation 23, Other Measures, Recommendation 28, Regulation and Supervision of DNF-BPs. ESAMLAG expressed major concern over the low level of suspicious transaction report filed by real estate agents because these reporting entities are considered to be present in representing high money laundering risk. In fact, ESAMLAG noted that there were no, I repeat, no suspicious transaction report with respect to casinos, real estate sector, as well as the jewelry sector. No suspicious transaction report filed by any operator in the real estate sector. And they are regulated since 2009. And the FIU has told the Commission of Inquiry that there is 24 cases of drug traffickers using real estate agents to money laundering. FIU has told the Commission of Inquiry that South Africans are using Mauritius through their lawyers to launder proceeds of crime. And yet, not a single suspicious transaction report filed by any real estate agent, by any public notary, and no action taken by the FIU against anyone in the sector. ESAMLAG was extremely critical of the FIU. ESAMLAG, then the report stated, and I quote, the level of AML, CFT compliance monitoring and supervision is virtually non-existent. The report also pointed out that with respect to real estate agents and dealers in precious stone, there were no specific measures in place to prevent criminals and their associates from entering the market and being the financial owners or holding a management function in the sector. Now, we all know, Mr. Speaker, sir, that the ESAMLAG report led to Mauritius being placed on the list of jurisdictions under increased monitoring, also known as the grey list of the FATF, which in turn led Mauritius to be placed on the blacklist of high-risk third countries with strategic deficiencies in their regime regarding anti-money laundering and counter-terrorist financing by the European Commission. So, Mr. Speaker, sir, the real question that we have to ask ourselves today, we are in 2020. The ESAMLAG report came out in July 2018. The Drug Commission, the Commission of Inquiry on Drug Trafficking, came out in July 2018. Why did we wait 2 years? 2 years before the bill comes before this House. Maybe if this bill came before this House 2 years ago, we would not have been grey-listed. Maybe we would not have been blacklisted. And we all know that there were experts, because the Honourable Minister of Financial Services stated in an earlier PQ that financial expert has been paid millions of rupees to advise government before it was placed on the grey list and the blacklist. So did government follow the advice, the recommendation of these experts? Or did they not follow? If they did not follow the advice, why? So I really hope in the summing up, the Honourable Minister, Deputy Prime Minister will give us an indication that why has there been so much delay in bringing this piece of legislation when we know that as far back as 2009, real estate agents were under the supervision of FIU and had not filed any suspicious transaction report. Mr. Speaker, sir, I would like to now comment on a few specific provisions of the bill. I do not propose to repeat all that my learned friend Adil Amiania has stated in his intervention, but I would like to emphasize that we should not lump together in the definition of the real estate agent all the operators, because each operator operates its own little cluster. So we have the courtier, the real estate, who acts mostly as an intermediary between the buyer and the seller, and this should not be treated the same way as those who deal with public funds, real property agents and land developers. And this is not unique to real estate professionals. For example, among law practitioners, Mr. Speaker, sir, among law practitioners, there is a different level of compliance with AML and CFT. If a law practitioner who only provide legal advice and do court representation and do not handle clients' money, the level of AML, FATF for these type of barristers and law practitioners is very low. On the other hand, if a law practitioner handles clients' funds and assists a client in setting up a company or act as an intermediary, then these law practitioners have to carry out a full customer due diligence on their clients. So I would urge the Honourable Minister, because he has a lot of power, by way of regulation, because if he doesn't propose to amend the bill, by way of regulation, at least to set different AML, CFT requirement for different categories of operators in the real sector, so that, especially the smaller courtiers, who are not courtiers marrons, the smaller courtiers are not penalized. Mr. Speaker, sir, I also join my voice to those before me who has criticized the bill for giving so much power to the Honourable Minister. We see at paragraph 8 of the bill, composition of the board, how the Honourable Minister is given power to nominate representatives on the board. Now, a proposed amendment has been circulated by the Honourable Deputy Prime Minister, and I'm glad to see that in this respect he has paid heed to our criticism that he should not interfere with who the Estate Agent Association or the Chambre de Notaire appoint as their representative. So this is fair enough. But then why is there no amendment being proposed to Section 8, Subsection 4, which provide that, and I quote, where a vacancy occurs in the membership of the board, the vacancy shall be filled by a person appointed by the minister, who shall hold office for the remainder of the term of office of that member. So it doesn't make sense. So if there is a representative of the Chambre de Notaire, he passes away or he decides to step down, why is it that it is the minister who has the right to appoint? It should have been the people who can appoint representatives should be given the power to replace those representatives, and it should not be the minister as Section 8, Subsection 4 is currently worded. Then if we turn to Section 12. Section 12, the appointment of the director, the chief executive officer. Again, it is not the board can only appoint that CEO, that director, with the approval of the minister. So why not leave this appointment to be done by the board after selecting the most suitable candidate after a proper, transparent appel de candidature? Why should it be the minister who has to decide who will be the director, who will be the CEO of that institution? And that is a very important, sensitive post, Mr. Speaker, sir, because this authority will have the power to set fees. This authority will have the power to take disciplinary action. So this authority should be seen to be apolitical, should be seen to be above politics. So why is it then that when it comes to the appointment of the chairman, the chairperson of the authority, there is a minimum requirement, that he has to be a law practitioner, but when it comes to the director, there is no requirement of a minimum qualification. To be a real estate agent, you need to hold a qualification to be a real estate agent, but to be the CEO, you don't need to have any qualification. So you can be a colonel à fiche for all the government cares. And I'm not saying this like this so lightly, Mr. Speaker, sir, because we've just seen what has happened to the Mauritius Standard Bureau. We've just seen how government wanted to impose one of their candidates as the CEO. The board refused. The chairman of the board was revoked. And in the end, Mrs. Sandhya Bogia, who has absolutely no experience, no expertise, no competence in Standard Bureau, was appointed.
Come to that being.
Yeah, this is an example of what we don't want to happen to the authority. We don't want a repeat of the Mauritius Standard Bureau with this authority, Mr. Speaker, sir. So if we look at then section 17 of the bill, security to be furnished by the real estate. This is very important because this is money. We're talking about money. And again, instead of allowing the board, the authority, to determine what is the level of security to be furnished by the real estate agent, Section 17, subsection 1 states that no person shall be registered as a real estate agent unless he furnishes a security in such amount as may be prescribed. So again, it is the minister who, by regulation, would determine what is the level of security that has to be provided by the real estate agent, whereas it ought to have been something left to the authority. Similarly, Section 20 of the bill, fees chargeable by real estate agent. Again, the fees for real estate agent in carrying out real estate transaction shall be of such percentage as may be prescribed of the value of the transaction, as may be prescribed. Who prescribes it? The Honourable Minister by way of regulation under Section 43, under Section 43 of the law. So the minister is the one who makes regulation. He's the one who's going to determine how much fees is being charged, how much penalty, how much security needs to be paid, how much charges, penalties, interest must be levied. So why? Why such a mainmise of the minister? Why doesn't he allow this power to the real estate agent authority? And it is worth noting, Mr. Speaker, sir, that in the model legislation produced by the Law Reform Commission back in February 2016, there were no extensive powers given to the minister. Most of the powers which is now attributed to the minister in this bill was actually left to the authority in the model legislation proposed by the Law Reform Commission. Now, with respect to the other provisions of the bill, Section 16, subsection 4 provides that no person shall be entitled to be registered as a real estate agent where he has been convicted of a financial crime offense. We don't have a problem with this. This is something that has been identified by ESAMLAG, by FATF, that there should be an entrance requirement for anyone in the real estate sector, because this is a high-risk sector. So we don't have a problem with not allowing a person who has been convicted of a financial crime offense. But, Mr. Speaker, sir, what is a financial crime offense? If we turn to Section 2 of the Act, it says, and I read, financial crime offense has the same meaning as in Section 41A of the Courts Act. Now, the problem is, we don't have a Section 41A of the Courts Act, because that Section 41A of the Courts Act was supposed to be enacted by the Court's Amendment Bill number 10 of 2020, which has been circulated and read a first time, but not been the subject to any debate and has not been passed before this House. So today we are asked to vote a law making reference to financial crimes offense, which doesn't exist, from a law which doesn't exist. So this is one of the niceties. So I don't know if by way of proclamation you can not proclaim that section of the law, but certainly you cannot legislate and refer to a law that does not exist. Finally, Mr. Speaker, sir, Section 19, Subsection 3. Section 19, Subsection 3 reads, any dispute pertaining to the performance of any contract may, if the party agrees, be referred to and settled by the authority. So the authority is given the power to mediate and arbitrate between a client and a real estate agent. The problem is, what would be the procedure used? What would be the rules of evidence? How would this hearing be conducted? Would it be adversarial? Would it be consensual? There's absolutely nothing. There's only one line in Section 19, Subsection 3. And this is very different, for example, when we talk about the disciplinary committee. The bill extensively describes how the disciplinary committee is set up, what is its power, who can constitute that disciplinary committee. But when it comes to this dispute resolution, there's absolutely nothing in the law. And we don't even know if that award will be final. Can it be appealed against? Can it be, because if it is arbitration, can it be appealed to the Supreme Court? On what ground? On only point of law? On point of fact? So this is totally absent from this bill, Mr. Speaker, sir. And I hope that by way of regulation, at least, the Honourable Minister will come and provide for the proceedings for guidance as to how the authority will conduct the hearing when it comes to resolving dispute. Mr. Speaker, sir, this bill was long overdue. Iceland and Mongolia, which were among the countries that were in the grey list of FATF in February 2020, were removed from the grey list of the FATF in June 2020. So let us hope that with this bill, we take a step closer for our removal from the grey list of the FATF and the blacklist of the European Commission. Thank you.